Estate planning can feel overwhelming, especially when it comes to understanding all your options. But if you're looking for a simpler way to plan for your future, avoid probate, and to maintain control of your assets during your lifetime, then a revocable living trust might be worth considering. Hi, I'm Anila Rasul with ASR Law Firm, and I'm an estate planning attorney serving families across Florida. Today, I'd like to take a little moment to provide you with a brief overview of one of the most effective estate planning tools available to us, the Revocable Living Trust. In Florida, a revocable living trust is commonly used to transfer assets efficiently after one's death, while allowing that person who created the trust, known as the grantor, to retain control of those assets completely during their lifetime. Unlike a last will and testament, a living will avoids the costly and lengthy probate processes. But this does require a little bit more strategic planning to ensure that the intentions of the grantor is honored during their lifetime as well as after their passing. Here's how it works. A revocable living trust is a legal agreement where the grantor, i.e. you, transfers ownership of their assets into the trust. While alive and competent, the grantor, you, typically serves as the trustee, managing and using those assets as they would have without the trust. Now, what sets the trust apart is that it's fully revocable during the grantor's lifetime. This means that it can be amended, it can be updated, it can be revoked entirely. However, once the grantor passes away or becomes incapacitated, a successor trustee steps in to manage and distribute all the assets in accordance with the trust's terms. At that point, the trust usually becomes irrevocable and can no longer be changed. Now, it's important to understand how a revocable and irrevocable trusts differ. While a revocable trust prioritizes flexibility and control, an irrevocable trust offers stronger asset protection, potential estate tax benefits, and can also support things like Medicaid planning. But it requires the grantor to give up control of the assets during their lifetime. Consulting with an attorney can help you decide which may be a better option for you. Once you've chosen the right type of trust, there are several important decisions that should be made thereafter. 1, identifying beneficiaries. These may be family members, friends, charities, or even pets. It's also wise to name contingent beneficiaries in case your primary beneficiaries cannot inherit. 2, retitling your assets. Assets must be properly titled in the name of the trust to avoid probate. This includes real estate assets, bank accounts, investments, and business interests. 3, select a capable trustee, ideally someone who is trustworthy, financially responsible, and free from any potential conflicts of interests. Now, a trust can also help with planning for incapacity in that if you become unable to manage your affairs, your successor trustee can step in without the need of court intervention and avoiding any kind of guardianship proceedings. This way, you will be preserving your dignity as well as your wishes. Also, families with minor children or dependents who maybe have special needs can also use a trust to include guardianship designations and provisions for managing their financial well-being over their lifetime. There are several Florida laws imposed on living trusts that are worth noting. They involve homestead protections for primary residences, fiduciary duties and obligations for trustees, and administration proceedings or procedures such as tax filings, beneficiary notices, and accounting. These legal nuances highlight the importance of working with an attorney who understands Florida-specific estate law. Now, finally, it's important to remember that your estate plan should evolve as your life changes. Marriages, births, deaths, relocations, or significant financial events are all reasons to review and update your living trust. So if you are seeking both flexibility and peace of mind, a thoughtfully drafted revocable trust may be your ideal solution. If you're ready to create or revisit your estate plan, I invite you to contact our office. We're here to guide you through each step of the way with clarity and care. Thank you so much for watching.